The ruling came as the Trump administration is seeking to rewrite Endangered Species Act regulations that scientists say would erode wildlife protection at the expense of commercial interests. The Trump administration's decision in June of last year to delist the grizzly, formally proposed in 2016 during the Obama era, was based on agency findings that the bear's numbers had rebounded enough in recent decades that federal safeguards were no longer necessary. Environmentalists countered that treating those bears separately from other grizzly populations in Montana and elsewhere in the lower 48 states was biologically unsound and illegal under the Endangered Species Act, and the judge agreed. Environmentalists have said that while grizzlies have made a comeback, their recovery could falter without continued federal safeguards. They point to, among other things, alterations in the bear's food supply from climate change and high levels of human-caused mortality. Judge finds reasoning illogical. The judge pointed to 2 studies cited by the agency that he said actually contradicted the government's own conclusions that the Yellowstone grizzlies could remain genetically self-sufficient. In his 47-page opinion, Christensen called the agency's reasoning illogical. The judge's ruling makes permanent a court order barring Wyoming and Idaho from going ahead with plans to open grizzly hunting seasons, allowing as many as 23 bears in the 2 states to be shot and killed for sport outside of Yellowstone Park. The season had been set to begin on September 1. Native American tribes, which revere the grizzly as sacred, sought reinstatement of its threatened status as essential to protecting their religious practices. Ranchers, who make up a powerful political constituency in western states, have strongly advocated delisting grizzlies, arguing the bears' growing numbers pose a threat to humans and livestock. Agitation for state management of the bears also came from hunters, who highly prize them as trophy animals. The judge said he discounted such factors. This case is not about the ethics of hunting, and it is not about solving human or livestock-grizzly conflicts as a practical or philosophical matter, he wrote. Instead, it turned strictly on his determination that the Fish and Wildlife Service had exceeded its authority. The agency said it stood by its delisting action, adding the was reviewing the ruling and considering next steps.